India's digital economy expanded in a fraction of the time it took for the country to build a foundational privacy infrastructure. This rapid growth occurred alongside an increase in cyber attacks and large-scale data leaks, which left consumers with little transparency or control over their personal information. The Digital Personal Data Protection Act of 2023 was designed to close this gap, mandating a legal framework that aligns Indian digital operations with global standards, like the GDPR. Under this law, personal data is defined broadly to include any digital trail, from a mobile number to a location tag, that can directly or indirectly identify a specific person. This legal correction ensures that data privacy is now an enforceable legal right for every citizen. To manage this right, the law defines the flow of personal data as a strict, legally binding transfer between two specific entities. On the left is the data principal, the citizen providing personal data. On the right is the data fiduciary, the organization determining how that data is processed. The burden of protection lies exclusively with the fiduciary, who is strictly accountable for securing this data everywhere. This bipartite relationship is the definitive legal anchor for all compliance and liability under the Act. Because modern organizations often rely on external infrastructure, the law accounts for a wider operational ecosystem. Data processors are partners handling data strictly on the fiduciary's behalf. Between them, consent managers act as gatekeepers, allowing citizens to easily withdraw permissions. For large-scale handlers, the law designates significant data fiduciaries, who must meet extra obligations like mandatory independent audits. While these entities share the workload, the fiduciary remains legally responsible for any failure in the chain. They cannot outsource liability to a third-party vendor. Historically, corporate data collection often relied on passive assumptions and hidden agreements that were rarely read by the user. The DPDP Act bans legacy dark patterns, like the pre-ticked boxes and hidden terms shown on the left. On the right is the new standard, a clear, active opt-in. For consent to be valid, it must be entirely free, informed, specific to the purpose, and easy to withdraw. Data collection involving anyone under 18 requires verifiable parental consent, making it a critical requirement for schools and edtech platforms. The law also imposes absolute prohibitions on children's data. Organizations cannot perform behavioral tracking, profiling, or targeted advertising on minors. Under this framework, every instance of data collection must be treated as a clear, provable contract rather than a default assumption. These new citizen rights introduce a set of external constraints that corporate database managers must now build for and respect. The data principal has the right to access a summary of all information held about them and the right to nominate a representative to act on their behalf. They can also demand the complete deletion of their data once the original purpose of collection has been fulfilled. Furthermore, citizens have the right to correct inaccurate data. This requires the fiduciary to maintain an active mechanism that allows a user's update to overwrite the old record in the central database. When purpose limitation is reached, data retention becomes a liability. Unnecessary data hoarding creates a surface area for litigation and regulatory fines. These legal mandates translate directly into the requirements for an organization's IT infrastructure and storage protocols. Under the DPDP Act, a technical cybersecurity failure is viewed by the regulator as a direct legal compliance failure. Active defense layers are mandatory. This starts with encryption for all personal data, in storage or transit. Multi-factor authentication and least privilege controls ensure employees only access data they need. Continuous monitoring tools like CM provide traceability and maintain required audit logs. A lost laptop containing unencrypted personal data triggers a mandatory report to the Data Protection Board and impacted users, regardless of the hardware's value. Other common vectors include misconfigured public cloud storage, which can accidentally expose payroll records or student biometrics to the open web. A provable cybersecurity architecture is an organization's primary legal defense against systemic failure. The regulatory transition in India has moved from simple warnings toward severe financial enforcement. For failing to protect personal data, an organization can be fined 250 crore. Failing to report a breach adds a 200 crore penalty. Violating children's data rules carries another 200 crore penalty. Ignoring privacy compliance now represents a specific threat to an organization's cash flow, as penalties scale directly with the severity of the oversight. Compliance is not just about having security, it is about proving it through rigorous legal documentation. The ROPA is the mandatory ledger to prove compliance. It tracks what data is collected, why it's needed, where it lives, and who accesses it. It must document storage timelines and specific security controls protecting that information. In a school ERP system, a secure-by-design architecture ensures transport drivers see bus routes but are barred from accessing student medical records or fee management data. Sensitive biometric data in these systems must be programmed with automatic retention limits, ensuring it is deleted as soon as its specific purpose is met. If privacy controls and data flows are not comprehensively documented in a ROPA, regulators will proceed as if those controls do not exist. For organizations shifting their legacy operations to meet these rigid compliance standards, the process begins with a systematic audit. First, map and classify all personal data across the organization, and translate existing privacy policies into plain, transparent language. The technical phase requires hardening security by implementing multi-factor authentication, encryption, and continuous audit logs for all critical data actions. Organizations must conduct rigorous risk reviews of third-party contracts and develop practiced incident response playbooks. Moving forward, privacy must be engineered into every new product and workflow from day one, rather than added as a patch after launch. Organizations that handle data with legal precision and technical transparency build a durable competitive advantage by minimizing regulatory risk.